Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you.
Thank you very much. And now I will introduce our speakers. First, I will introduce Michael Nebenzahl. Michael brings over 40 plus years of extensive litigation experience to his role as a mediator. A seasoned trial attorney and respected legal professional, Mr. Nebenzahl has handled some of California's most complex and high-stakes civil cases, including public entity defense, catastrophic injury claims, and civil rights litigation. Throughout his career, he has developed a reputation for civility, professionalism, and the ability to navigate even the most contentious disputes to resolution. He balanced perspective stems from years of experience on both sides of the courtroom, having begun his career at a prominent plaintiff's personal injury firm before transitioning to decades of defense litigation, representing municipalities, transportation entities, and businesses. And next, I'm going to introduce Robert Glassman. Robert is a partner at the nationally recognized plaintiffs firm in Los Angeles, Panish, Shea, and Ravipudi, where he represents plaintiffs in large and complex personal injury cases. He has been named a top 40 lawyer under the 40 by the LA Daily Journal, a leader of influence thriving in their 40s by the LA Business Journal, and has obtained numerous 7- and 8-figure jury verdicts as a lead counsel, earning him membership in the invitation-only American Board of Trial Advocates. Mr. Glassman graduated from Southwestern Law School in 2009, currently serves on the school's Board of Trustees, and also teaches a jury selection class to Southwestern students. Before law school, Mr. Glassman graduated from Bucknell University in Lewisburg, Pennsylvania, where he majored in English and was the student body president. So those are our speakers for today. And with that, I will hand it over to Mr. Nebenzahl.
Thank you, Anna. Robert, a pleasure to do this with you. I'm sure we'll both chat as we get on about maybe the summary judgment we had against each other not that long ago. But wonderful to be here with you. Anna, if you can take us to slide 2. And so this is an overview of what is ahead for the next hour about how to bring a summary judgment, how to defeat a summary judgment. You have the strategies presented by both the defense and the plaintiff side. Most importantly, you must know and must follow CCP 437C and the critical rules of court 3.1350. We're going to talk about the structure of a motion, deadlines, and experts. What I want to convey at the outset is this is a CLE that really is about how to bring a motion and not any specific law on any particular motion for summary judgment. This is a helicopter perspective about how important it is to know and follow the rules, and some practical trench advice from both Robert and myself. So Robert, your comments here, please.
Thank you very much, Michael, and it's a pleasure to be with you as well. And Anna, thank you for the kind introduction. Before we get started, I do want to briefly mention that motion for summary judgment that Michael and I had against one another before he decided to retire from the practice of law and to help us resolve cases as the esteemed mediator that he is today. And I think this was one of the last motions for summary judgments that you actually litigated, Michael. I don't know if it was the last, but I know it was one of the last ones. But for everyone out there, I just want to tell you a story about civility, because Anna brought it up during Michael's introduction and how he has practiced with such civility throughout his career. And I want to emphasize how important that is. So one of the last cases that Michael had as a defense lawyer was a dangerous condition case that my firm filed against the city of Alhambra. And this is something that I'm going to get to in just a moment. But every single dangerous condition case, of public property, you have to assume that the defense is going to be bringing a motion for summary judgment. That is just one of those causes of action that is going to prompt a summary judgment motion by the defense, any kind of dangerous condition of public property claim. So this was a dangerous condition of public property claim against the city of Alhambra, and a tree had a branch fall. It failed from the tree at a park and fell on our client, and she had suffered some pretty bad spinal injuries as a result. So Michael was the defense lawyer, I was the plaintiff's lawyer, and I just looked this up before we started the program, but in June of 2024, Michael sent me an email and said, hey, look, I'm just giving you a heads up. I am reserving a date for our motion for summary judgment in October. That was 4 months away. He didn't have to give me that heads up, but he did. He said, I'm filing a motion for summary judgment in October. We've reserved the date for October 11th. And I just want you to know that I'm reaching out to you because in our answer to the complaint, we did not plead an affirmative defense of trail immunity. And throughout the course of discovery, we believe that trail immunity is now a defense that we can assert, and we'd like to raise it in our motion for summary judgment, but I can't because I didn't plead it in the answer. Will you stipulate to us filing an amended answer so that we can assert that argument in our motion? And being the civil guy that I am, I agreed to stipulate to the city and to Michael filing that amended answer to include trail immunity as an affirmative defense. So trail immunity was ultimately asserted as a defense in the motion. We opposed it. And then in Michael's reply, do you remember this, Michael, what you did in your reply brief to the motion?
I do. Go ahead.
Michael yes. Specifically wrote, and I went back and looked at the reply brief at the end of the introduction paragraph. Lastly, we acknowledge plaintiff's citation of Topi versus City of San Diego. And in light of that, we no longer are claiming trail immunity as a defense in this case. And I think that was just such a good example of why civility matters and why it makes sense and why it's healthy and productive to get along with opposing counsel, because all we want on both sides is just to really get to the merits of these cases and dispense of them or proceed with them based on the merits. And that's what happened in that case. I agreed to allow him to amend the answer. He made his argument in the motion. We found a case that said trail immunity doesn't apply when it involves trees and dangerous conditions of trees. And then, like a gentleman, in his reply, he said, okay, we acknowledge that case and we're no longer claiming it. So that was just a really good example of civility, Michael. And I once again appreciate you inviting me to be here. And I think that if we didn't have such a good relationship when you were a practicing lawyer, we wouldn't be doing this together.
Robert, thank you. One quick comment, because it's really appropriate for the big picture of something we're both going to talk about throughout today. And that is the significance of that by both of us was how the court appreciated it and how it lessened the issues for the court to deal with all of the papers and materials that they had. And what's so key to bringing a motion and defeating a motion is being concise and respectful and taking up the court's time only on the issues that are necessary.
Couldn't agree more. So with that, Anna, could you move to the next slide, please? So look, every time we file a case, we do have to anticipate that, a motion's going to be filed. But there are certain causes of action that we flag that we know are more likely than not going to prompt a motion for summary judgment. I already mentioned it a moment ago. Dangerous conditions of public property cases typically always are going to have a motion for summary judgment. Whether it's a tree case, whether it's a dangerous road design case, you can pretty much count on the defense always filing a motion in those cases. Cases involving course and scope disputes. Those are cases where we're assuming a motion for summary judgment is going to be filed. In today's day and age, or recently now with rideshare liability, those are cases where we anticipate motions are going to be filed. Was the DoorDash driver an employee or an independent contractor? We're saying employee, defense says independent contractor. There's going to be a motion for summary judgment on that issue. Certain product cases oftentimes result in motions being filed. So if you have a straightforward negligence case, like an auto case, a rear end accident, whatever it is, a T-bone in an intersection, there's not that many issues going on in that case that are going to necessarily warrant a motion for summary judgment. But I would say without fail, dangerous condition cases, product cases, course and scope disputes, and rideshare liability cases are the cases that we've seen in our experience that are always warranting or prompting a motion for summary judgment. So because of that, from the outset, we have to look at the Casey jury instructions. For every plaintiff's lawyer out there, just know that is like standard of care. When you file a case involving one of those claims, look at the Casey jury instruction early on to know what your burden is. It's your burden. It's not the defense's burden. You need to know what elements you need to prove. So once you look at the Casey jury instructions for a dangerous condition of public property, draft written discovery, tailoring your request to try to establish those elements that you need in order to prove that. And we're going to get into kind of what to look for in depositions and how I deal with depositions once the motion's filed. But I would say looking at the cases early on, figuring out what your elements are, and then tailoring your written discovery to establish those elements from the outset is something that you got to do. All right, let's go to the next one.
Okay, so following up from Robert, anytime you get a new file in the office, you want to make sure that you have the entire file. And so in order to assess whether or not you can or should bring a summary judgment or a summary adjudication, you simply must make sure that you have all of the necessary information. So it's not just the pleadings that presumably you will get, and hopefully the correct complaint. There may be a first or second amended. You need to get the file documents from your client if they haven't accompanied the file. And you may even need to interview certain individuals from a company, certain employees, and it may be up and down the food chain from manager down to someone actually on the product line or someone who's filling in a pothole or whatever the case may be. You need to have the entire file in order to make the assessment as to whether or not it makes sense to then build the case to whether or not you're going to bring a summary judgment. And along that line, you must also know and understand the complaint. You must know and understand the legal issues for each cause of action alleged in the complaint. And then you do an assessment before you even decide which way to go. Is this a case you might want to demur or not demur? Because that may make the motion for summary judgment or summary adjudication easier or harder, depending upon the case, depending upon the variety and multiplicity of causes of action. And so there's a strategy that needs to be considered from day one with respect to the overall, I love this word, gestalt of the case, of the defense, and see which way that takes you. Also at the beginning, are all of the parties in the case? Are there going to be cross complaints? Have they all appeared? And all of these things are just the basics of getting your ducks in a row before you now have determined if this is a case that's appropriate for summary judgment or summary adjudication. And once you're there, you then take the time to set out a clear and thoughtful discovery plan. And that is very much geared toward not just written discovery, but who do you want to depose? And bear in mind, as we go, jumping way ahead, but bear in mind, when you file that motion, if you haven't taken a necessary deposition and you haven't found out the bad news as well as the good stuff for your motion, you're going to, after you filed your motion and before the opposition is filed, and you're going to be in a predicament. So you want to have a good, solid discovery plan in mind. You want to make sure that your client is supportive of the cost and the process, and that they have given you all of the materials and allowed you to speak to the individuals necessary who either A, may be deposed, or B, who you may need a declaration from. And
I just want to point out,
Yeah.
I just want to point out too, Michael, that, on the demur issue, one of the easiest arguments for us to make on the plaintiff side when we get a demur is that this is just a premature motion for summary judgment, or that this is a demur, or a motion for summary judgment disguised as a demur. You're asking the court to now rule on whether or not there's sufficient evidence, basically, for this case to move forward. And this is not the appropriate time or place to make that argument. If we make a mistake in the actual pleading because we fail to plead causation or fail to plead an essential element in our claim, then yeah, bring a demur. But it is such an easy argument for us to make that this is premature. Let's do discovery and let's have a discussion on the merits, not some premature discussion based on, a disguised motion for summary judgment.
Along that line,
Recently, like, demurs are being filed very sparingly. I don't see them that often anymore.
well, that's what I was going to comment on, Robert. I think in the last 20 years, maybe 30 years, I could count on one hand how many demurs I've brought. I can also tell you that I'll need a calculator for how many times I've picked up the phone. That's something that some of us still do or used to do, and called the other side like Robert, and I have said, I think there's a problem with the complaint. I don't want to demur. I don't want to incur the time. I don't want to delay your case. I don't want to cost my client more money. But let's discuss this. Would you consider filing a First Amendment complaint? And I think 95% of the time, every time I have done that, I've received a First Amendment complaint without any objection whatsoever. And then we move on from there and proceed to determine whether or not a summary judgment can be brought. So,
Okay,
Anna, let's go to slide 5. Okay. This is the bread and butter. I hope that everyone on this webinar is familiar with 437C. This is really basics. This is just the timeline. For those of you who haven't brought a summary judgment motion in a year or two, the code was amended, I think in 24, 25, from 75 days to 81 days. Just know the code. But my footnote and comment here, other than the simple data here, is today's world, it's all e-service. Bear in mind that the code, which wraps itself around e-service these days, however, that does not equate to same-day service. So if you're doing e-service, you still have to add your 2 days onto your notice requirements. Now, something else I have done on almost every motion for summary judgment for the past several years since we've come into the e-filing world is, again, I've called up the other side or I've sent them an email. And I've said, you're going to get e-service on this, which is same day and not at 5:15 or 4:59 at night. Can we stipulate that e-service is equivalent to personal service by hand so that I eliminate those 2 extra necessary days of service? And the answer is almost always yes. But you must confirm that in writing, and you must have that as one of your exhibits to your motion, and it must be in your declaration in support of the motion. So when you get to court and the clerk looks if there was timely notice, you can direct the court or the clerk to that email indicating that e-service qualifies you for 81 days instead of 83 days notice on service. And then you're okay. With respect to the timeline here, my other quick comments are these. Do not bring the motion too early, and of course, don't bring it too late, because too late is not a good thing. When you bring the motion, you are entirely in control based upon the timeline. And so you can set the narrative, you can set the theme. You're going to hear this from me repeatedly today. Know your proof, have your exhibits, have your depositions, have your declarations, and know that when you file your motion with any deposition or exhibit attached, someone like Robert is going to turn around and immediately notice a deposition that he needs for his opposition. And if you haven't heard what that witness has to say, you've lost the opportunity to control the motion. And as the moving party, that's the key to getting out of the box first and in control of the narrative. And so you have to follow these timelines, but you want to work them with your theme and your plan and making sure that you have the necessary proof for your motion.
Yeah, and also one thing to keep in mind from the defense perspective is if you attach, and I know we're going to get into this, but if you attach a declaration to your motion from an expert that who you think is going to help you dispose of a cause of action or the entire lawsuit, you need to be prepared to produce that expert earlier than you otherwise would have to under the expert exchange rules. And sometimes you're even going to subject that expert to 2 depositions, because once you put that declaration in that motion, we're going to want to take that expert's deposition for purposes of defeating the motion for summary judgment. And then once the expert exchange is done, then we're going to want to depose that expert again for purposes for trial. So that's also something that you should keep in mind, that you might be subjecting your expert to 2 depositions and we get 2 bites of the apple.
And all I can say is I agree with what Robert says. That's a risk, and we'll talk more about experts later, but yeah, absolutely.
Okay, let's go to 6.
So I'll start, and then Robert will comment, because this is where we both have a burden of proof. Ours, of course, is to win the motion. It's critical to understand that in order to succeed on a motion for summary judgment, any cause of action has multiple elements that are necessary. On the motion for summary judgment, you simply must disprove one of the necessary elements that a plaintiff must prove. And if you can knock that out, you will have won. Concurrently, on the same thought pattern, if you can establish an affirmative defense, you then can also prove your motion. Now, it's slightly different when we talk about motions for summary adjudication of issues. You must, with respect to a summary adjudication, defeat the entire cause of action. A long time ago, the rules were such that you could maybe defeat a factual issue or a part of a cause of action. But the rules are very clear now. If you bring a motion for summary adjudication or in the alternative summary judgment, on each summary adjudicated issue, you must defeat the entire cause of action, if it's cause of action 1, 2, 3, or 7, 8, 9. In order to bring this motion and be prepared to establish your burden of proof, you've got to know the facts of your case, and you've got to know the law for each cause of action that's going to be the subject of the motion, so that you can, of course, prove it. And hand in hand with this is what we've already started to talk about, is you must have the necessary exhibits, and you must use them wisely in putting together your motion to create your proof. And wisely means such things as, because you lead with the motion as the first document read by the court, you set the theme, you set the narrative, you set the tone, and wisely you will set the order with which you spell out your exhibits. And you want to keep that in mind, tactically and strategically, as to how you want the court to see the motion and the exhibits and in what order. And if it's done right and things go well and Robert's having a bad day, the defense might win. But that's a tough road to hoe. In any event,
those do happen.
Go ahead, Robert.
Yeah. So, I mean, look, after your introduction paragraph in the opposition, you have your summary judgment standard, right? What's the standard for summary judgment? And there's a half a dozen cases that stand for the proposition that all you need is just one dispute as to one fact, and you should win that motion. If there is just a single dispute about any factual assertion being made by the defense, the motion should be denied and the claim should go to the jury to decide. And don't be afraid to say that to the trial judge. This is a case that involves not just one, but several triable issues of fact that are in dispute. It would be unfair to the plaintiffs and the defense, really, but mainly for the plaintiffs, to terminate their cause of action in this case before a jury can decide. Let a jury decide. Let's get to the merits. Let's have a fair fight and let a jury decide who should win and who should lose this case. It's not up to the trial judge. If it was simply just a legal issue, the trial judge can decide. But when there's a lot of disputes as to what happened in the case or what should have happened, a jury should decide that. A trial judge should not decide that. So it's very important early on in your opposition to underscore that principle. This is something that involves a lot of disputes. Let's let a jury decide. And something that I like to do in my opposition is, Michael talked about the defense kind of creating the theme because they're the ones filing the motion. In my introduction paragraph in the opposition, I'm telling the trial judge something that they don't know yet because it wasn't included in the motion itself. So it's new evidence for the judge. It's not new evidence in the case because it happened in a depot or we got it through a document production request or something from an expert. But I'm telling the judge a new fact that right off the bat creates a factual dispute regarding the case. And so that's I always strive to, in my very first sentence in the introduction, to introduce something new to the judge that wasn't included in the motion. And not just anything, but a new important fact that shows the judge right from the outset that, all right, okay, so the defense didn't mention the fact that the department store was on notice 30 times of people taking knives off the shelves and using them in some kind of dangerous way in the store. I'm referring to a case I had against Target involving third-party criminal conduct where a criminal took a knife from the shelf and used it on our client and brutally stabbed them. And, there was a motion for summary judgment in that case because notice is another issue that oftentimes you'll find a motion for summary judgment gets filed on. And, in the motion, there was no evidence for the judge to see about all the prior incidents of knife attacks at the store. So we started our opposition with that. And I just think if you frame the issue appropriately, if you've got the evidence, then the judge has already decided there's too much dispute here for me to grant this motion before they even finish reading your opposition. And just so you know, at the end of this PowerPoint, I know this PowerPoint's available to everyone, but Michael's email address is on it. My email address is on it. You can always email me for examples of oppositions to MSJs that our office has filed, and I'd be glad to share those with you.
So Robert, great comments and points. And all I can say is the challenge for anyone who is setting forth their motion and wants to control that narrative has got to anticipate what Robert's going to do. And so you have to, not as a burden of proof, but as a burden of responsibility to tell your story and keep control of it, anticipate what he's going to do and deal with your bad facts and explain briefly how these aren't disputes and those 30 other cases, they don't mean anything. You have to deal with it, and you're going to have to deal with it. And the worst time and place to deal with it is in a reply brief, which we'll talk about in a few minutes. But Robert's point is excellent and well taken.
But so is yours, Michael. I mean, I think as the defense lawyer, you're going to lose credibility with the judge if you don't anticipate those obvious things that the plaintiff lawyer is going to say. If you totally omit that from your motion because it's not a good fact for you, that omission is worth more than just acknowledging it in the motion. So spend time as the defense lawyer, spend time trying to, soften the blow of the bad facts in your motion rather than just taking the easy way out and just not mentioning it at all.
I don't, it's wholly inappropriate for either of us to get political today. But videotapes don't lie, and they're often part of motions. And so don't try to talk your way around something that is absolutely self-evident in an exhibit, a document, or videotape. And you must deal with it and address it with credibility. So let's go to slide 7, Anna.
Can I use that, Michael, in my next case where I've got a video of the accident and I think it's clear as day and the other side is saying that it doesn't show what it actually shows? Can I say that, look, a prominent former defense lawyer says that videos don't lie? I'd love to use that because my last 2 trials all involved an incident that were captured on video, and to me it was crystal clear, but for some reason we were fighting about it in the trial, what it actually showed.
I think the expression is, are you going to believe your lying eyes or what I tell you? Okay, so required components. We're both going to comment on this in terms of the moving party. Again, the obvious is there. The notice, the memorandum of points and authorities, your separate statement, the necessary evidence, and if there's a need for requests for judicial notice. That's the easy part. From the defense side, the most important thing you have to realize, it dovetails with what we've just been talking about, is you've got to win your motion on your moving papers. You cannot lay back and rely on a reply brief. You must tell your story. You must base it upon the facts. And the required component of winning a motion are the separate statement of undisputed material facts. And a critical failure on the part of far too many motions for summary judgment is they're put together with way too many separate statement facts. The rule, the cases, the code requires you to set forth the necessary material facts that are required to win the motion, to disprove an element. And that does not mean that all of your facts are material. Every time you add an additional separate statement fact, you are giving Robert or any plaintiff's attorney an opportunity to raise and to challenge it as a dispute. So less is clearly more. We'll talk about this again shortly. In terms of what's required on the summary adjudication, this is a critical area that often is misunderstood. The separate statement of material facts can become long, sadly, unfortunately, frustratingly, but the rules are clear. If you are seeking summary adjudication and/or summary judgment, you must have each separate statement fact spelled out sequentially per each issue to be summarily adjudicated. So if you have a cause of action with if you have a complaint with 5 causes of action and you're bringing a summary adjudication on 4 of the 5 and not a summary judgment, you must have a separate statement list for each of the 4 causes of action that you are addressing. If you're bringing it on the entire motion, so you have a motion for summary judgment and or summary adjudication on all 5 causes of action, you effectively now have 6 separate statement series of facts that are required. It's enormously burdensome. It's required. Robert?
Right. I mean, and I'll just underscore that again. I mean, the presumption is going to be that if you put it in your separate statement, you thought it was material, because that's the rule. Just put the material facts in. So if you're putting a ton of facts in, to Michael's point, that just gives us more opportunities to dispute one of them. And if we dispute one of them, we win. So make sure you're only putting in what is absolutely necessary. It's annoying for us when we get separate statements that have 55 facts, because we got to deal with it all, but it's worth the annoyance because it means we're more likely to win. When we get motions with 10 facts and they're actually substantive and material, we're a little bit more worried, even though it might be easier for us to kind of deal with that. So I think as a general rule, as a defense, you want to use as few facts as possible. And then on the plaintiff side, when you're opposing it, you better put in additional material facts. Don't just respond to and dispute the facts that the defense is putting in. You better take the opportunity to set forth a litany of additional material facts every single time. Do not just count on you disputing their facts to win. You better be adding other material facts in your separate statement response. Just a couple of technical points here. Every time we get a motion for summary judgment served on us, someone on our team will right away email opposing counsel and ask them for a Word version of the separate statement, which they are required to send to us, because the response to the separate statement has to match up perfectly with the formatting to the separate statement that was used by the defense. So if you're on the plaintiff side and you get a summary judgment, automatically make the request from opposing counsel for a Word version of the separate statement, so you can then, obviously you're going to change the heading and the firm name and all that. You're going to put your firm name on it, but you're going to keep, the formatting the exact same so that it's consistent. Make it very easy for the judge to review. The judge should be able to look at the defense separate statement on the left side, and then over here, look at the responding separate statement. And it should look the exact same. There's just going to be more text in the one on the right, because there's now our responses to their separate statements, and then there's our additional separate statements that we're now asking the defense to respond to when they file their reply. So I think that's also really important to keep in mind. I'll tell you this. I mean, I don't automatically dispute every fact that is set forth in the defense separate statement. I think you gain credibility with the judge by stating unequivocally undisputed to the undisputed things. I mean, don't just dispute things for the sake of disputing them. You'll lose credibility. So if the defense puts a sentence on their list that says the incident happened on Tuesday, January 7th, 2025 at 7:54 p.m., don't dispute that. Just say undisputed. It's okay to not dispute some of their facts. I think you gain credibility. What's not listed on here under the opposition are objections, but I know that's contained somewhere else in the PowerPoint. But serve objections to some of the evidence that the defense uses in their moving papers. Whether it's deposition testimony or a document or a photograph, there's typically always something you can make a good faith objection to. And I oftentimes find that it comes like in a deposition. If they're citing deposition testimony, serve an objection to the portion that they're citing to from the depo and state the grounds for your objection, whether it's lacks foundation, hearsay. Of course, in a motion for summary judgment, you can make substantive objections that you ought not to make during the actual deposition. So if someone's saying something that's hearsay, object on hearsay grounds in the motion for summary judgment.
Okay, let's move on as our clock is ticking away, Robert. Anna, to the next slide. So let me jump in here quickly and briefly because we still have quite a few slides to get through. We've talked a lot about the separate statements. My additional comment here is the best way to clinch defeat from the jaws of victory is to have too many separate statement facts on the defense side. You want to keep them, you want to keep the statements themselves short and succinct. Realize that your motion will be filled with facts, but not all facts are material facts. And so you need a lot of facts to tell your story, to keep your narrative intact and running along smoothly. But there's a huge difference in distinction between what's material to prove or disprove an element of the cause of action. Robert, comments?
Yeah, briefly. I mean, on the other hand, and this is in the handout that we provided, the name of the case that stands for this proposition, long considered the golden rule of motions for summary judgment. If it's not in the separate statement, it doesn't exist. And there's a case site that we use in our handout for you to put in every single opposition that you get. So if the defense is arguing something in their motion, but it's not in the separate statement, you better cite that case and say motion has to be denied based on that alone. If it's not in the separate statement, it doesn't exist. Don't consider it. So Michael's right. Use it, only put the essential ones in there. But if you're going to make an argument in your motion and you realize that you don't have a separate, a statement in your separate statement that you need to make that argument, you better put it in there before you file it.
Okay, next slide I think is for you, Robert.
Right. So like I said, you want to serve objections pretty much with every single opposition you file. There's typically something that you can object to, whether it's a depo or a document or a photograph. The affirmative evidence that you're using in support of your opposition, make sure that it's admissible, that you lay the appropriate foundation. I see this most often with expert declarations. Obviously, you can't just have your expert go straight to his or her conclusions or opinions, lay the foundation for those opinions and conclusions in the declaration, spend time working with your expert to make sure that the foundation's there before you get to those ultimate opinions. And as it says here, if you don't object to clearly objectionable evidence in your opposition, you run the risk of that being waived at the time of the hearing.
Just a quick comment on this is I believe there's a concept out there called the sham declarations, and there's a case Thompson versus Williams, 211 Calap 3rd 566. And of course, no defense lawyer is going to put forth a sham declaration in the moving papers. So you want to be on the lookout for any declaration in opposition. And of course, Robert's on the lookout for it in his opposition as well, of course. But you want to look up, you want to be on the lookout for that, because a declaration to clean up a previous deposition testimony doesn't clean it up on a motion for summary judgment. You can't submit a post-depo declaration to create a contradiction or dispute a fact. And that's just an important concept to keep in mind.
Before we move to the next one, let me just take a moment to tell everyone kind of what my what my method is in actually opposing these motions. Like when it gets down to it, when I sit down at my desk, what's the first thing I do? I will print out, this is just my method. I print out every single deposition that was taken in the case. And I read every single page of every single deposition. And then I will extract testimony that I will then turn into kind of a factual statement. And then I will cite to that factual statement with the deponent, page, and line cite. And I'll create a new Word document. And what I'm doing is I'm pulling out all the salient facts that I need to oppose this thing from all the depots, and I will create a separate Word document that will be the basis for my statement of facts in my opposition. And I don't have to get it in the right order right away when I'm doing that new document, but I just want to make sure I have the whole universe of facts that I think I need in order to successfully oppose the motion in a clean Word document. And then once I get all those facts from all the depots in this clean document, then I'll start kind of moving them around, and I'll say, all right, I think that, this fact should go under this heading under the statement of facts, and this one kind of fits under this section towards the end of the statement of facts, and I'll arrange it that way. And that, for me, has been very helpful in making sure I'm capturing every piece of evidence I need to successfully oppose the motion.
I want to make a comment on what Robert said. And when the defense brings a motion for summary judgment, the defense is entirely in control of when to bring it. And in theory, and hopefully in practice, all of the ducks are in a row. And when the motion is filed, it's actually ready to be filed with all of the supporting evidence. The plaintiff doesn't have that luxury. They're up against a critical timeline as soon as they're served with that motion. And what Robert was explaining is what makes a good lawyer. What Robert was explaining is why he's as successful as he is and his firm is, because of the work and the labor that he puts in to oppose a motion. To my plaintiff friends out there, and I have many, and to Robert's brethren out there, do not wait to the last minute. To oppose the motion requires putting in the time and the effort and the legwork that Robert was discussing. And time, effort, and legwork will always pay off to your benefit.
Yeah, we often say at our office that, opposing a motion for summary judgment, it's probably like the second hardest thing you can do in civil litigation from a plaintiff's lawyer's perspective. The trial is probably number one. That requires the most preparation and hard work. But after that, it's the motion for summary judgment. So if you're saving it for the last minute, you're not going to win. The motion's probably going to be granted. You gotta really that's the time to really roll up your sleeves and dig in and go through every single page that's been created in that case.
Because it is a mini trial, and you have to prepare as though it's a trial, because the judge can decide that trial on that motion or not. So, Anna, next page, please. Next slide. So for those on the defense, the timelines are simple here. Follow the rules. 11 days before the hearing. Again, if you're e-filing, it's 13. So make sure that you get a stipulation to do it with only 11 days. You want to be brief and focused. But most importantly, if you have any sense of confidence that you're going to be able to rely on your reply brief to win the motion, you are mistaken. You cannot present a single bit of new evidence to try to explain or win your motion. The notice requirements are 81 days notice on evidence to support your motion for summary judgment. You cannot then bring in new evidence only 11 days before the hearing. It's just absolutely unacceptable and in contradiction to the rules and the CCP 437C. The reply documents, the reply brief must be short. You are not retelling your story. Remember, all these timelines and all of the papers, the court is not reading them once when we file the motion and then when the opposition and then the reply. They're reading them all at one time. And you don't need to retell your story. You simply must address critically important things that come up in the opposition, hopefully explain them away. Limit your reply objections to only necessary objections. Have credibility. Don't object to an entire paragraph or an entire page from a deposition. Be surgical. By the time the court gets to the reply brief and the reply objections, they have spent hours, hopefully, and hours on this document. And the last thing you want to do is waste precious time, whoever's reading these papers, on really unnecessary ticky-tack, time-consuming papers and objections.
And you can do what Michael did in the COA Alhambra case that we talked about at the beginning of the webinar, which is if a good point's raised in the motion, in the opposition, and it's not going to totally dismantle your entire motion, make the concession in your reply. You know what? That's a good case citation. We're no longer going to make that argument, but for the following reasons, we should still win. I think you gain credibility with the judge if you do that. There's a case that we always cite to in our opposition, in the last section of our opposition. And again, you can email me for copies of this. And in the case of the San Diego Watercrafts case, which says, we're just kind of, we're preempting the issue on new evidence in the reply. We're saying, there's a Court of Appeals case that says the defense cannot assert any new evidence, include any more evidence or new arguments in their reply. So we're just pointing that out. We're flagging that right now. And because they can't do that in the reply, and because we already have shown that there's triable issues of material fact, this motion should be denied. Sort of like telling the judge the reply is meaningless. They can't put any new evidence in under longstanding California law, and we've already created tribal issues in our opposition. It's done. We don't even want the judge to consider the reply. So that's kind of the last section that we put in every single opposition.
A good point to raise. Yes. Next slide. We really have to move quickly, Robert. Opposition themes.
A lot of these things we've talked about. The biggest point to make legally in your opposition is that one dispute equals a denial. There's tons of good cases that stand for that proposition. The one thing that we haven't talked about yet is if you think you need more evidence in order to successfully oppose the motion, and you've shown due diligence to try to get that evidence, but for whatever reason you can't, then cite to 437C subpart H, which says the court can either deny the motion on that ground alone, or they'll continue it to give you the time to get the evidence you need. And this is really going to trying to dispose of issues on the merits. So if you make a good faith showing in a declaration that you've tried to get this deponent's testimony that you need in order to oppose this motion, but the defense is stonewalling you, or it's not the defense's fault, it's just the witness has been unavailable for whatever reason, make a showing in a declaration that you need that in order to oppose the motion, and cite to that section 437CH. And ask the court to either deny it straight up or continue it to give you more time.
And a smart defense attorney will not object to that. He'll take the position, he or she'll take the position in front of the court. We just want a fair hearing on this, and we think we're going to win. So let's have all of the cards on the table and put forth this issue so the court can resolve the matter efficiently for all of us.
Let me say one more thing on opposition themes briefly. There's a case called Aguilar that we also cite to in every single opposition that says, you know what, you can deny this motion on basically procedural grounds because the defense hasn't shifted their burden to the plaintiff. They haven't even met their burden to show that they've disposed of all the issues. And so because they haven't even met their burden, you don't even need to go to the substance really of the motion. You don't need to determine if there's factual disputes because they haven't shifted their burden. And that's what the Aguilar case stands for, and that's what we cite to in every opposition as well. And I've had motions denied based on that. They say, you haven't totally disposed of all the issues. We don't even need to go to plaintiff's opposition because under the cause of action, there's still this element that you didn't prove is not in dispute. So just be mindful of that as well.
Okay, next slide. Let me quickly talk about experts and the use of experts on motions for summary judgment. There's a rule of thumb that I have lived by for many, many, many years. If you can bring your motion without an expert, do so. If you need to use an expert on a motion for summary judgment, you are going to get a counter declaration, and that counter declaration from that expert has you can have a 90+% probability that he or she is going to make every effort to raise a dispute and counter what your expert says. And Robert's going to say, we now have a disputed fact. So you must use them extremely sparingly, sometimes necessarily, but sparingly. Robert?
Couldn't agree more. I mean, I think we've touched on that already now. You know, don't put in stuff that you absolutely just do not need.
Okay, so next slide, please. Quick comments. Know your audience. Be concise. Respect the court. Organize your motion, your exhibits. Be civil, be professional, as Robert and I have conveyed from the very beginning. Be mindful. In today's world, I see judges have over 1,000 cases. To get them to read a motion for summary judgment is a challenge. You must be concise. You must be credible. Limit your objections. Limit your long objections or citations or counter citations in your separate statement. Be civil, don't attack opposing counsel, and be timely. Robert?
I've seen judges get pissed, yell, scream when formatting issues are messed up on a motion for summary judgment. If the separate statement doesn't look like the one, you know, if they don't look alike, if the one in your opposition looks differently from the one in the moving papers, they'll get mad. Make it easy for the judge. If you're this is a big one. If you are citing specific testimony in a deposition, highlight the part that you are citing to. If you want to reference something on page 12, lines 6 through 15, highlight lines 6 through 15. Make sure you're doing that before you file your papers.
Next page, next slide. Robert, these are quick, practical tips. We have just a couple minutes.
Sure. I mean, so again, just we've touched on this already. For me, I like to introduce new facts. They're not new facts in the case, but new facts to the judge as the first thing you say out of the starting gate in your opposition. Tell the judge the worst fact in the case for the defense. Tell them that in your first sentence. And I can show you examples of how we've done that. You want to use your worst fact for the defense in the first sentence in your introduction. Obviously, like I said, object to testimony that lacks foundation, that lacks personal knowledge. You want to do that pretty much in every opposition you file. As I just mentioned, don't assume that the judge is going to read everything that you put in there. I think we've both said that. So if you want the judge to pay attention, highlight it, underline it, repeat it, bold it, put it in italics, do something that will make it stand out.
Let's go to the next slide, and I'm going to ask our participants if they can hang with us for maybe 2 or 3 minutes. We'll get done. We just have one more slide. Control the narrative. Target a missing element, pick your strongest facts, acknowledge weaknesses. So now what this means is make your point and move on. Attack the plaintiff's weakest link, be credible, and do not repeat yourself. And my last and most important one, as I've now retired from practice, and I can say this with a sense of comfort because I'm no longer in the trenches, be careful in any reliance on AI for your research. You all probably read a case this past, I think, September or October, where a Los Angeles attorney was sanctioned $10,000 for 21 of 23 false citations on a summary judgment and an appeal. Do not blanketly rely on AI. Be careful, be concise, be respectful. So now we have last slide. Robert, what are your final takeaway comments?
Yeah, I mean, just as what you can see on the screen here, I mean, one thing I'll just tell you is that when I'm taking a depo and a witness says something that I know is, what I would consider like a smoking gun or one of the best lines that I think is going to be used in the entire case, I make a mental note. I'll put it in a separate document that this witness said this, and it's going in the first paragraph of my opposition to the motion for summary judgment that I know is coming in this case. So it really is something that you have to think about during depositions. I would say most importantly during depositions, you got to be thinking about the motion for summary judgment during those depos. From the plaintiff side, just keep your ears open for those key concessions and admissions that you're going to hopefully get from a witness that is going to defeat the motion. So track all that while you're deposing these people so that you know kind of where you're going to go when the motion gets filed. So it's pretty daunting if you don't even have an idea of how you're going to oppose the motion when it gets filed. Usually when we get a motion, it's like, all right, I knew this was coming and I already kind of know the key things I want to say right up front. If you don't have that in your mind when the motion gets filed, it's just another added step and it becomes even more daunting for you. So that's what I would say in sum.
So I want to remind you all that in the handouts, I believe there's an appendix A and B, and that's where we really spell out the particulars from CCP section 437C and rules of court 3.1350. My final takeaway is I cannot emphasize enough how critically important it is to follow the examples that are set out in 3.1350 on how to lay out your separate statement, on how to even cite to the accompanying exhibits and support, and how to frame your how to frame your objections. And the two formats that are allowed so that all of the papers are presented to the court in a moving packet, and there's usually 5 or 6 documents that are presented, so that you fully comply with the rules and the format and the citation requirements and the way in which you must do it, to not give a court some excuse to bounce it or to just deny it. Thank you.
Don't take the easy loss. If you're the moving party on a motion for summary judgment and it gets denied because of a procedural mishap or a technical mistake, you did your client a real disservice. So follow the rules closely, precisely.
Robert, thanks for joining me. It's been a pleasure.
I had fun doing this with you, Michael. Happy to do it anytime. I'm glad to see you now as a mediator, and you've always were so thoughtful and substantive in the cases that we had against each other. And I couldn't recommend you more as a neutral now in this new chapter of your life. Thank you.
Well, thank you so much. Take care.
Thank you so much, Michael and Robert. That was wonderful. I know we didn't have a lot of time to get to the Q&A portion of the program. So if you do have questions, feel free to email Robert or Michael at these email addresses below.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.